Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. This is our video podcast here at Absolute Trust Counsel. I'm Kirsten Howe. With me is Jessica Colbert, one of our associate attorneys. And what we're going to talk about today is how do we access a decedent's bank account after their death? This is a very popular question. We get it a lot. Usually it's in the form of, I tried to access the bank account and I failed. The bank won't let me. What do I need to do? We get a lot of clients in that situation. So Jessica, let's start by, how do we access a decedent's bank account? What happens to the bank account after the owner dies?
Well, that's going to depend on how the owner owned that account. And there are many different ways that an owner can own a bank account, such as it can be a pay on death account, also known as POD. The owner can own it outright alone. The owner can own it jointly with another person, or they can own it in a trust.
Okay, so those are very common ways for people to own bank accounts. And what you can do after this decedent dies is going to depend on which form of ownership. But I just want to get one more thing out of the way. A lot of our clients who've been, let's say, while the decedent was alive but not very healthy, they were assisting the decedent with this account because they had a power of attorney and they were able to do that. That's not going to work once our decedent has died.
Right. So after the owner of the account dies, the power of attorney is no longer valid. And the agent under that power of attorney may not access those accounts anymore. And that is actually illegal. So that means that the agent can't use the ATM card. They can't write a check. They may not access the account online anymore. Not only is that it's illegal, but it's also a breach in their civil duty as agent. And at that point, the agent has a duty to then turn over all the assets to either the executor of the estate or the successor trustee if the decedent had a trust.
Okay. So what you're saying is maybe the agent can do those things. They still have the ATM card. They still could be using it, but it's not legal. So don't do it. Okay. So let's go back to the beginning. We had several different ways that our decedent could own this account. And let's talk about how we access each one of those types of accounts.
First, I'll talk about joint ownership. That's the easiest case. That's a case where there is now one joint owner who is deceased, and then the asset just belongs to the surviving owner in that case. So the surviving owner will go to the bank with a death certificate, and then the bank will remove the decedent's name from the account.
Okay. So that is pretty simple, pretty straightforward. The surviving owner just continues on and now it's their account. Okay.
And a pay on death account is similar. The person who is designated as the beneficiary of that account will go to the bank with a death certificate and the money will be released to them.
Okay. So same process, just go to the bank with your death certificate. You're going to have to show some ID, obviously. The bank's not just going to take your word for it that you are the person named in that beneficiary designation, but that's pretty logical. I think we all would have anticipated that you guys show up with your driver's license. Okay. Another form of ownership is trust ownership. So the decedent's bank account is actually titled in the name of the decedent's trust. This one's another easy one. The successor trustee goes to the bank with his new certification of trust. That's just a document where he says, I am now the trustee of this trust, and here's my taxpayer ID number. They're going to get a new taxpayer ID number for this trust because we can't use the decedent's social security number anymore. That gets retired when you die. So our successor trustee shows up with certification of trust, new taxpayer ID number, and the bank will just take the money from the decedent's account and put it into a new account for the trustee of the trust with his new taxpayer ID number. And then he just goes on and he can write checks and make deposits, all the things. So that's another pretty straightforward one. And we got one more to tackle, Jessica.
Yes. And this last one is where it gets a little bit more complicated. This is when the owner owned the asset just outright in their name alone. And this means that they did not own it in a trust. They did not have a beneficiary designation on it. And if all of the assets that the decedent owned in its name alone total $184,500 or more, the person named as the executor in the decedent's will have to open a probate. They're going to have to get the court to issue letters testamentary The executor will then take those letters to the bank. They'll have to get a new taxpayer identification number for the estate. They'll take that number to the bank as well. And then they will open an account in the name of the executor as the signer on the account. And this is the worst process. It takes the longest, it costs the most, and it's a probate. And we want to try and avoid that.
Right. We don't want probates. Okay. And just a little embellishment on that. If the decedent didn't have a will and the same facts apply, then somebody else has to open a probate. They would be appointed by the court as the administrator of the estate. They would be issued letters of administration and they would do the same process. It's just a question, did the decedent have a will? Then they're an executor. Didn't have a will? Then they're the administrator. But it's the same process. You got to get letters from the probate court. It takes a long time. Okay. But you did say, Jessica, that $184,500 is our threshold for a probate. If our decedent didn't have $184,500 in his name, all he had is this one bank account that we've been talking about, and it's only worth $20,000. Now that changes the procedure. Let's talk about that.
Yes, then it becomes a much easier procedure. The person who is entitled to that account, which would either be the beneficiaries under the decedent's will, or if the decedent didn't have a will, the heirs entitled to it under the probate code. Those people or that person would go to the bank with what's called a small estate affidavit. And that is a document that the beneficiary or heirs is signing under penalty of perjury. They are claiming that there is not a probate and there is no need for a probate because the assets are under that $184,500 threshold. They're declaring that they are the people entitled to that asset and also that 45 days have passed since the decedent died.
Okay. So that's certainly less burdensome than doing a probate, but you do have to wait 45 days and you do have to, if there are multiple beneficiaries, you got to gather them all up. Everybody has to sign it. Probably everybody has to go to the bank together. I'm really clear on that, but I think that's true. So, not ideal, but it's certainly better than a probate.
Yes.
Okay. I'm just going to say, I think that we can't always know because sometimes all you know is the decedent had a bank account and you don't know if there's a pay on death beneficiary. But if you can figure that out, what form of ownership did we have? It's best to know that before you go to the bank.
Yes. And when you go to the bank, also bring whatever you need with you to get access to that account.
Yeah. Because sometimes the bank, the person showing up wants to access the account and they're not the right person. They're not equipped. They didn't bring whatever they're supposed to bring. And the bank just freezes the account. And it's a whole other fiasco trying to unwind that. So be prepared, show up with whatever it is you need. Okay, thanks, Jessica. I think this was very informative. I'm sure it will be helpful to a lot of our listeners. I hope you got a lot out of it, everyone listening there. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.